Thank you all for joining this. This is the part 3 of the Landmark Chambers Planning High Court Challenges webinar series. And we've got a lot of people joining, and we've got a lot to get through. And we hope you'll find that helpful and informative. I certainly will, because I've been out of this for some time, as you know. My name is Robert Carnwath. I was, as you probably know, a Supreme Court Justice until a year and a half ago, and I'm now an associate member of Landmark Chambers. I'm very pleased to be able to chair this session. I will be introducing the speakers in a moment. Just a few housekeeping points. Your microphones are automatically muted, so you will not need to adjust your local settings. You're very much encouraged to submit questions through the session, and please do that through the Q&A section by text, which should be at the top or bottom of your screen. You can either remain anonymous when not asking a question, in which case please tick the send anonymously, or preferably from my point of view, it'd be good if you would identify yourself and your organization. We will deal with the questions at the end of the presentations. The webinar is being recorded, and there'll be a link to the presentations after the event concludes. Sorry. If your connection is lost at any point during the webinar, we invite you to rejoin the meeting by clicking on the original link once more. Now, turning to the speakers, we have 4 speakers. We first have Tim Buley, Queen's Counsel, on the role of the OEP under the Environment Act. We then have James Maurici QC on the Future Planning High Court Challenges, JR Reform, the Planning White Paper, and Levelling Up and Beyond. Then we have Georgina Fenton on Practice and Procedure Update, including Aarhus costs. And then finally, Habitat's Case Law Review of the Year by David Elvin, Queen's Counsel. Now, I'm boldly going to assume that Tim, James and David are reasonably well known to most of you. They've all been involved in high profile cases in the Court of Appeal and above, and many planning inquiries. Georgina may be slightly less well known to some of you. She's a relatively new member of Chambers, but she's very experienced, having had the benefit of being judicial assistant to Lord Justice Keith Lindblom, and I think worked on the Heathrow case, among other things, which must have been a very good introduction to this whole area. So she's, in her own way, as expert as everyone else, and so I look forward to hearing from all of those speakers. So we'll start off then with Tim Buley on the role of the OEP under the Environment Act. Over to you, Tim.
Great, thank you very much, Robert. So I'm going to be talking, as Robert says, about the role of the OEP, the Office for Environmental Protection, under the very recently enacted Environment Act 2021. I've been talking about this topic in one form or other for the last couple of years because it goes back, this is the government's legislation which was designed to ensure, among other things, I think, but importantly, kind of the continuation of significant environmental protection following on from Brexit. And the OEP was created, or was to be created, was first envisaged, I think at the end of 2018, as effectively a replacement body for the European Commission. I'll come back to whether that's a realistic or meaningful goal in a moment. But in one way or another, the OEP therefore has been in conception for quite a long period of time, but the Act finally received royal assent only this month. So whereas the OEP has now existed for about a year or so as a shadow body, we now have an actual Office for Environmental Protection. It's got its own website. You've got the link there in the slides. What is the OEP? Well, it's a new body corporate, and its principal objectives, and therefore its function, its basic purpose, is set by Section 23 of the Act, which says that the principal objective of the OEP is to ... contribute to environmental protection and the improvement of the natural environment. Those are its functions. Those are its purposes, rather. What it's not given is any direct functions in relation to the protection of the environment, akin to those, for example, which are enjoyed by bodies like the Environment Agency or, for example, local planning authorities. Those functions are left untouched with the appropriate pre-existing public body, so the Environment Agency, whatever it is. It's very much not a replacement for the Environment Agency in particular. And instead of those specific functions of granting consents or dealing with flooding problems or whatever, it's given two broad sets of functions. First of all, the scrutiny and advice functions under sections 28 to 30, and secondly, and I shall say a bit more about in this talk, focus on in this talk, its enforcement functions under section 31 to 41. Now, those functions, and it is critical to understanding what the OEP is, those functions are all to be exercised in relation to other public bodies. The OEP doesn't exercise functions directly in relation to private individuals or private companies or environmental campaigners or any of those sorts of organisations. It may, as we'll see, have important interactions with them, but it doesn't exercise its functions in relation to them. So I think the best way to think about the OEP is it's a sort of regulator's regulator. Its function is to regulate the way in which direct or frontline environmental regulators exercise their functions, keep them on the straight and narrow, check that they're performing their own functions. Now, as I said, the original conception here was of a body that would replace the European Commission, which had arguably a somewhat similar relationship. But there's an absolutely critical difference in my mind between the OEP on the one hand and the role the Commission played previously, because the role of the Commission was effectively to oversee the compliance by the UK, then an EU member state, with wider non-national environmental legislation, in particular European EU legislation. Whereas the role of the OEP is very much a step below that. It's to ensure the compliance of individual UK public bodies with environmental law, which is principally now to be set by Parliament. And so that is a pretty important difference in its role. And in a sense, therefore, it seems to me it's not correct to think of it as analogous to the Commission. It's a new body, one that we haven't experienced, at least in this area. Some analogies outside of environmental law, you might think of it having a role a bit like an ombudsman, but we'll see it's arguably got slightly more teeth than an ombudsman. You might think of it as having a role a bit like something like the Equality and Human Rights Commission. That was sometimes thought of as a model. So that's the OEP as a whole. Now, the focus of these seminars is obviously on High Court litigation, so I'm going to skim over some broad stuff about the OEP and then focus on what I think is the most important role of the OEP from a High Court perspective. Very briefly, the OEP is required under section 23 of the Act to prepare a strategy. It hasn't done so yet, but you can see get a sense of the OEP's role from the matters that the OEP strategy is required to focus on. So that is to say, prioritising cases that it considers may have, and you can see the things I've underlined on the screen, national implications relating to ongoing or recurrent conduct, serious damage to the natural environment, or points of law of environmental law of general public importance. There's a potential overlap between its role and that of the Committee on Climate Change, and it's required to do certain things to kind of mediate that relationship, but I won't go into that here. So, as I say, it's got two sets of functions. Its advice and scrutiny functions exist under section 28 to 30. Very quickly, their monitoring and advice functions in relation to environmental plans, in relation to implementation of environmental law, and in relation to giving advice to ministers. It's not in any sense directly relevant to High Court planning litigation, although of course the fruits of those functions, reports and the like, may be important. It may become important evidentially in environmental and planning judicial review. Let's take in a little bit more detail then the enforcement functions. So the OEP has enforcement functions under, as I say, sections 31 to 43, all of which relate to failures by, this is the critical phrase, failures by public authorities to comply with environmental law. And in relation to that basic test, it's got three main enforcement functions. First of all, consideration of complaints and the carrying out investigations. Secondly, environmental review. And thirdly, it has a role in bringing and intervening in claims for judicial review. Now, a couple of things to say about those. Two of those, and this is why it becomes an important player in the High Court planning field, two of those are High Court litigation functions. So environmental review is effectively a statutory form of judicial review in most respects, and judicial review, of course, is judicial review. Note that, on the other hand, there's an important divide here in that the first two of those functions, bringing complaints and investigations on the one hand and environmental review, are intimately linked. The environmental review takes place only at the end of and at the conclusion of the investigation process. I'll explain how that works in more detail in just a moment. So let's look at the, just before we look at investigations and environmental review, let's just focus a little bit more on this phrase, failure to comply with environmental law. You might say that's a phrase which I think, as judges like to say, it rests on its own bottom. It's obvious what it means, but in fact, it's not quite so clear. So it's defined, a reference to a failure to comply with environmental law is defined in section 31(2) as meaning, note meaning not including, two things: unlawfully failing to take a proper account of environmental law, and unlawfully exercising or failing to exercise any function which the public body has under environmental law. And environmental law, by the way, is defined in section 46 as relating only to legislative provision. So it doesn't bring in, as it were, the common law, for example, common law nuisance. Lots of issues and problems which will have to be worked out in the cases about this. The oddity about that definition is it seems to narrow rather than widen the meaning of failure to comply with environmental law, because curiously what it doesn't seem to cover is a straightforward breach of environmental law. Now, presumably the courts will interpret a failure to take proper account as meaning failure to comply with environmental law duty, but it's an oddity. There's a real question about how the OEP considers what it means to breach environmental law from its perspective. Is it limited to a judicial review role, or does it go wider than that? Again, points I've already touched on. Really, it's focused. This is very much focused on action by public bodies. Perhaps we can get into some of that more in the questions, but I'll leave that there. And then the processes itself. Well, as I say, two of the functions are intimately linked: complaints, investigations, and environmental review. So, looking at complaints and investigations, the basic idea, looks very much like an ombudsman, is that a member of the public can make a complaint to the OEP about something they regard as a failure. No limitation here on the subject matter. This is why suddenly this becomes important to planning, because planning certainly will be included within this. And then the OEP can carry out an investigation. There's some detailed provision about how it does that. It can require information from the public body and so forth. But that process will go on in a relatively informal way. But critically, it can then lead to an outcome, which is if and only if the OEP thinks there has been a failure to comply, it can issue a decision notice. And the decision notice is a notice, see section 37, which describes the failure of a public authority to comply. It explains why it has reached that conclusion. Then critically, and this is the key provision, sub C, sets out the steps the OEP considers the authority should take in relation to the failure, and which may include the steps designed to remedy, mitigate, or prevent recurrence of the failure. And then the public authority can indicate whether it intends to take the steps. So there are two critical points to make about that. First of all, that the recommendation which the OEP makes is non-binding. The public authority need not comply with it. That's similar to, for example, the ombudsman model. But secondly, and this is absolutely critical, and it's something I'm not sure the government fully appreciated even towards the end of the design of this legislation, what the OEP doesn't have is the power either to set aside or require the public body to set aside or quash the action in question. Now, think about a planning permission, for example. Suppose the OEP considers that a planning permission then has been wrongly issued. Well, the OEP, I suppose, could recommend that the public authority would revoke the planning permission using its statutory powers, but leaving aside the very bespoke statutory powers to revoke planning permission, which require the payment of compensation and relatively rarely revoked, it doesn't have power to quash or to recommend that the authority treats the planning permission as quashed. So at this stage of the process, what one has is something that doesn't look like it has much teeth, certainly in the context of planning, where we are used to the court quashing the matter. But that's one way you get to the next stage of the process with the next enforcement function, which is the environmental review function. Because if we go on to that, section 38 then provides that the OEP may apply to the court, apply to the High Court in England and Wales at least, for an environmental review once a decision notice has been issued. And there are a number of key features of this. First of all, the environmental review is brought and can only be brought at the conclusion of that investigation and following the issue by the OEP of a decision notice. Secondly, that the subject of that application is the underlying conduct of the public body. So the OEP is not concerned here with the public body's response to its recommendation. It's concerned with rather with the underlying illegality, which it thinks it's made a finding on, but which it will now have to establish once again in the environmental review process. Thirdly, and critically, no time limit for bringing of the environmental review claim. There's no time limit either by reference to the timing of the original decision nor the process the OEP has carried out. And statutory ouster clauses are ignored. Now that's a pretty radical thing, because if you think about, for example, a decision of the Secretary of State to grant planning permission on appeal, well, in theory, that's challengeable only by way of statutory review because there's an ouster, no other means of challenge. But for the purposes of environmental review, you ignore that ouster. And also, curiously, the highly likely test, which limits the grant of relief in planning, is also ignored. And the role of the court is effectively the role it has in relation to judicial review, but with those changes. So that's a pretty radical new process. It's a form of High Court challenge which can be brought to a planning decision, for example, or to environmental decisions, including planning decisions, and without any of the safeguards which normally apply. But there is instead one other critical safeguard, which is that other than in relation to the grant of its principal remedy, which is simply a finding of non-compliance by the public body, what the ER court must do is limit its remedy, and there are major restrictions on remedies, because it can only grant any other form of remedy where one of two conditions applies. Condition A is that, see subsection 9, the court is satisfied that granting the remedy would not be likely to cause substantial prejudice or hardship or prejudice to third parties, or detrimental to good administration, probably less important. And condition B is subject to an exceptionality threshold. There must be an exceptional public interest and serious damage to the environment. Now, condition A there will look familiar because that's the test that the High Court applies where in granting any remedy in judicial review, but only where there has been delay, and then substantial prejudice in judicial review is then linked to that delay. What's curious and rather extraordinary about the condition A is that the limitation of remedy to cases where there's been no substantial prejudice is not linked to delay. Now, if you think about a planning permission, for example, well, obviously the quashing of a planning permission will automatically prejudice the party in whose favour it's been granted, unless they've lost interest in carrying out the development in any event. And so in practice, therefore, having said that you've got this rather extraordinary process by which all of the normal safeguards of judicial review have gone out the window, time limits and the like, in fact, very difficult to grant a remedy, other than in cases involving condition B, where first of all, the court is satisfied there's serious damage to the environment, but secondly, there must be an exceptional public interest. Now, we don't know how the courts are going to interpret that. Big question mark. On the one hand, you've got this kind of door wide open to a new form of High Court process, no time limits, nothing like that. But on the other hand, these rather strong restrictions on remedies, the court's approach to which has yet to be established. I'll skip over this slide because I'm conscious of time, but I think there's an issue about the interaction between investigations by the OEP on the one hand and ER on the other, because of the way that they seem to be really aimed at different targets. And yes, and yet they have to take place in tandem, and I think that imposes major problems. How does this apply in the planning field? Well, just very briefly then, what sort of thing can this be used to? There's no limitation on the subject matter of this. It's any environmental area, and that will certainly and obviously include most, if not all, planning matters. So the possible targets, well, unlimited really, but notes some very important ones. First of all, planning permissions. As I've said, this is really a potentially radical new ability to bring High Court challenges to planning permissions where there's no time limit. Most planning permissions in major developments are backed up by insurance, which is linked to the expiry of the 3-month time limit for judicial review, but that's not going to have any relevance because you can bring the OEP can bring a claim long after the expiry of that 3 months. No protection for the planning permission if it's highly likely the outcome would have been the same, and so on. So that's a radical new measure, but it may be rare in practice for this to make a real difference. Why is that? Well, it's not going to be attractive to complainants for various reasons to do with the fact they have to go through the investigation process first, and they won't be in control of the process. The process has to be brought by the OEP, not the individual. There's that key restriction on remedy, which may flip the dial, as it were, and mean that remedies won't be granted in practice. And also, and think back to those early slides, the OEP's strategic priorities, limiting itself to important cases, recurring problems and so forth, important points of environmental law, will mean that it's not going to get involved in these cases, in planning cases routinely. But in important cases, it does have the potential to do so. Other targets, well, development consent orders, similar considerations apply, but of course, almost by definition, a DCO is much more likely to meet the OEP's seriousness threshold. So we may see the OEP getting more involved in those sorts of cases. And then the one that I think is actually most interesting is in relation to plan making, because, for example, there's nothing to stop the OEP carrying out an investigation and then bringing in environmental review in relation to the acceptance by local authority, adoption by local authority of the new local plan. And many of the restrictions on the way in which the courts approach those sorts of High Court challenges will not apply to the OEP, because it can probably, or it seems to me, a strong argument that it can grant remedies in relation to individual policies of the plan, for example. Time limits are going to be less important here, and less and arguments about prejudice to third parties more finely balanced, at least. So I think there's an it's interesting to think about, at least, whether the OEP will choose to involve itself in that sort of challenge. Lastly, then, in terms of the OEP's functions, is the separate matter of judicial review. The OEP is given a bespoke power to bring judicial review proceedings of its own. There's a limitation on that, which harks back in part to the seriousness point, that it will only involve itself in serious cases. And then it must also meet what's called the urgency condition, which is that the action for judicial review is necessary to prevent or mitigate serious damage to the environmental or human health. That is not, although it's called in the statute an urgency condition, it's not phrased, it's not the actual definition of what urgency means, doesn't mention urgency. But I think the idea here is that these are the kinds of cases where, perhaps because of the problems of obtaining a remedy in environmental review, that these are cases where the OEP is able to conclude that it really needs to bring action straight away to prevent the harm, and so it can go for judicial review. It's also given a power to involve itself in judicial review proceedings as an intervener, and it will be interesting to see how it uses that power. What all of that means, I think, and these are early days, we don't know how the OEP is going to go about interpreting these powers, using these powers. We don't know how they'll be interpreted by the courts, but the OEP is now a potentially significant new player in High Court planning, environmental litigation, and therefore inevitably High Court planning litigation. A critical issue as to how that plays out is how the OEP sees its role, and also, I think, and I don't think we really know this yet, how well it's been resourced by the government, because if it's on a shoestring, it will get involved in a relatively small number of cases. But whether you are someone who advises private developers, environmental charities, NGOs, or public bodies who are themselves directly the target of the OEP's concerns, this is obviously something you need to be familiar with. And I hope that overview has been of use. So thank you for listening, and I shall hand you over to James.
Hi, thank you. Thanks, Tim. So I'm looking at the future of planning High Court challenges by looking at some things that are on the horizon. what I want to pick up on is the Judicial Review and Courts Bill that's still going through parliamentary procedure. The planning white paper, obviously, I was hoping I might have a bit more detail from the government about what's happening on that. I think we all thought we might, which I guess goes to prove the quotation which I've begun with, that it's difficult to make predictions, especially about the future. I'm then going to cover some aspects of the Environment Act, not the OEP, which Tim's just covered, but the stuff in that Act in relation to environmental principles. I'm then going to look briefly at the levelling up agenda, which is obviously very big, and how that is going to play out in terms of High Court challenges. And then just pick up, if I have some time, on one or two other trends which I see developing at the moment and which I think are likely to carry on into the future. So the Judicial Review and Courts Bill, there's obviously been a pattern of the government since about 2012 now of making incremental changes to judicial review aimed very explicitly and directly at limiting it. And the other aspect of the way the government's behaved on this is that the trend is to issue a consultation paper or something similar, proposing numerous and very radical changes, and then doing something much, much smaller. And the Judicial Review and Courts Bill follows that pattern, but presumably, as this trend develops, we can expect more changes. And I'm going to come to one aspect of that in a moment. So there, in the actual bill as presented, there are only two clauses that were potentially relevant, and one of them on CART judicial review is not really relevant to planning, which leaves us really with the first of the provisions, which is explicit provision that a quashing order may include provision for the quashing not to take effect until a date specified in the order, or removing or limiting any retrospective effect of quashing. So effectively seeking to introduce the possibility of prospective quashing, as it's called, only in the future. If the court is going to go down the line of considering that, the bill as currently drafted asks that the court must consider a number of things: the nature and circumstances of the defect, detriment to good administration, etc., and the interests or expectations of persons who are going to be affected. And then there are other factors that have to be considered. So that's the one that's most relevant in terms of the bill as it was introduced into Parliament. What you may have seen, though, last week was some excitement in terms of some proposed amendments to the bill that have been made by backbench MPs, Conservative MPs. A number of them don't really affect planning, but there's one clause that's amongst these amendments that have been proposed at the committee stage, headed Evidence in Judicial Review Proceedings. And it says, as drafted, unless there are compelling reasons to the contrary, no court shall, 1, permit oral evidence to be elicited in judicial review proceedings, or 2, order public bodies or any other person exercising or entitled to exercise public authority to disclose evidence in anticipation of or in the course of judicial review proceedings. So a pretty extraordinary provision, hasn't got government support yet, but effectively it would mean not just no cross-examination other than exceptional circumstances or compelling reasons, which isn't probably very far from where we are now, but also no disclosure in judicial review unless there were compelling reasons. So truly extraordinary amendment, but we'll see whether that gets picked up. I would very much hope not. I'm going to then turn to the planning white paper. Obviously, none of us really know where we are on that. You'll remember the history. Back in June 2020, the Prime Minister said no more newt counting delays. And this was slowing down house building. He said that in the recovery, we needed to build back better and greener, but also faster. We then got the white paper, the consultation closed over a year ago. Secretaries of State to the relevant department came and went in numbers. And we really don't have very much more clue where we're heading, except, of course, what we then had was the conference speech where the Prime Minister moved complete 180 degrees from his concerns about newt counting delays to saying no more building on greenfield sites. That's a statement which has itself already knocked off course several local plans. Is that policy? Some people at inquiries are already trying to argue that's government policy, but of course it's not government policy at the moment. It's not reflected in the NPPF or in any other policy. It doesn't have that status. It's a conference speech about what policy might be in the future. Where does that leave the white paper? Well, so far our new Secretary of State's been pretty Delphic about this. Apparently the white paper, which caused so much concern, was mischaracterized. Apparently there was lots that was good in it. Not sure I've spotted that myself yet, but we'll see. That it was all being considered, and we'll hear in future what's going to happen with it. But just a few things on the legal side of it. Obviously, one of the big things in there was zoning. That was one of the big issues. Will we see that? I doubt it now. But if we do, what are the legal issues? Well, I mean, one is if you're going to have a plan that gives you planning permission, then you shouldn't be doing SEA of that plan. You probably need to do EIA. Does that matter? Does that matter in terms of the strength of the obligations in each? Well, I think it matters a bit, because it's quite clear on some of the recent case law that the degree to which you need to assess things is less for SEA than EIA, because you're at a higher level. You're at the plan level, you're not at the project level. If you're zoning, that's no longer true. You're actually consenting the project through the plan. And similarly for habitats, there's case law, HS2, but also the Advocate General and Commission in UK, recognising that the extent to which one has to delve into habitats issues may be less at a plan stage than a development control stage. But of course, that's no longer true if your plan is going to be a vehicle through which consent can actually be delivered. And then I can't really see how one can combine speeding up plan making, which every government wants to happen and never does, versus the increased work and importance of plans if they actually allow for something really like zoning. And if zoning were to happen, if plans were to have that effect, it would only increase obviously the number of challenges that would be made to plans, because you would have to hit it at that stage because the plan gave you consent. In terms of other changes that were mooted in the white paper, there's the infrastructure levy. I mean, we're still struggling with legal issues from SIL. It was introduced 11 years ago now. See the recent controversy over the Stonewater case. It seems unfortunate that we're going to start again with an entirely new regime. And then replacing Section 106, well, I mean, I just don't see how you can do that. It obviously serves far more purpose than simply financial, and I don't really understand where that's going. Hopefully going nowhere. So that's the planning white paper. I wish I'd been able to say more, but we don't know more. Can I then just turn to the Environment Act? And obviously Tim's covered the OEP. I want to cover another aspect of the Environment Act, which I think is going to have some influence on future planning and environmental litigation. So Section 17(1) requires the Secretary of State to prepare a policy statement on environmental principles, EPPS. And this is defined as a statement explaining how the environmental principles should be interpreted and proportionately applied by ministers of the Crown when making policy. Section 17(4) says the Secretary of State has to be satisfied that EPPS will contribute to the improvement of environmental protection and sustainable development. And then the effect of all this is Section 19(1) provides that a Minister of the Crown must, when making policy, have due regard to the EPPS that's currently in effect. Now, there are a couple of exceptions to that. Policy on armed forces, defence, national security, taxation, spending are all excluded from that. The principles are that environmental protection be integrated into the making of policies, preventative action to avert environmental damage, the precautionary principle, rectification of environmental damage at source, and the polluter pays principle. So these are the environmental principles. 19(2) clarifies that the statement does not require a minister to do or refrain from anything that would have no significant environmental benefit or would in any way be disproportionate to the environmental benefit. The government consulted on a draft of the EPPS earlier this year, and it's absolutely riddled with references to proportionality. That seems to be a very strong sort of guiding principle throughout it. Is that a concern? I know it's a concern in some quarters that these principles, which the whole purpose of which was to try and sort of replace these principles that came directly from the EU treaty, but which are now not part of retained EU law, to give them some force. Is it a concern that proportionality is such a high level issue here? Don't know. We'll have to see how it plays out. The draft EPPS contains some further definitions of the principles and guidance on their application, but really the definitions are quite limited. But it does give some examples of possible actions that the government could take when formulating policy, having considered the principles. So amend its policy options, reframe the policy, etc., or postpone a policy even. And the interim OEP gave some advice on these draft principles when they were published. What's explained in the draft document is that the legal duty applies to ministers. So when making policy, it doesn't apply to other decision makers, doesn't apply to ministers when doing things that's not policy. And this is policy can be broadly understood as an intended course of action adopted to achieve an objective. And then there are examples given of policies. Obviously, the key point is that it doesn't apply to individual decisions by ministers. And of course, it doesn't apply outside of ministerial policy making. Why do we need all of this? Well, as I said, these principles were originally derived from the EU treaties, but they're not retained EU law under our Brexit legislation. Obviously, I've talked about the scope being limited only to ministers of the Crown making policy. And I think what we're going to see is a lot of argument about how some of these principles might come to play in other ways. If, for example, you can't rely on the EPPS because you're dealing with a non-ministerial decision, how can you, for example, bring the precautionary principle into play? Well, numerous ways, it seems to me. One is that principle is itself directly embedded in some legislation, like habitats. And, you know, we obviously got the habitats regulations, which are retained EU law, and they contain that embedded embodiment of the precautionary principle in Regulation 63, giving effect to what was Article 6.3 of the directive. Secondly, there are obviously European court cases which potentially suggest the precautionary principle and some of these other principles potentially are general principles of EU law. And if they are, then they would be retained EU law. You've also got a route to the precautionary principle through the Trade and Cooperation Agreement, which does specifically refer to the precautionary principle and indeed some of the other principles as being relevant in the environmental sphere. And then I think there may also be arguments that come to play about whether the precautionary principle is actually part of our domestic law now. If you're going to argue that, you've got the case of Duddridge to deal with, a divisional court decision quite a long time ago now, 1995, saying it's not. But you do have more recent Court of Appeal authorities where, although the point wasn't sort of directly addressed, the Court of Appeal seems to have proceeded on the basis that the precautionary principle was in some way part of our law. And then there's another route potentially, which is, you know, is there actually room to argue that the precautionary principle is now customary international law and therefore part of our common law? Is there a route forward to that? So I think these things are going to materialize because we're losing a number of key principles that have come to us from EU law. We've lost those. The attempt to replace them in the Environment Act is limited really to ministers making policy. Is there going to be argument about how we can get these in other ways? I think inevitably there will be. And then in terms of the other principles, you know, it's not just the precautionary principle. There are other principles here which we could also argue were part of our law. I just note on the polluter pays principle, Lord Carnwath, in the Fishermen and Friends of the Sea case, which was a Privy Council case, referred to the polluter pays principle being firmly established principle of international and domestic environmental laws. So that's, you know, potentially a similar route to the one I was talking about, customary international law becoming part of our domestic law. Is there room for international law to push forward the principles of our domestic law now? Potentially there is. I move off the Environment Act, talk about a couple of other things which I can see coming up in the future. One is levelling up. Obviously, this is a big thing for the government. The importance of it's been underlined by the renaming of the department. just to see the kind of litigation we're going to face, I mean, you can already see the Good Law Project's got a judicial review of the Levelling Up Fund. You can see their explanation of it on crowd justice. They call it pork barrel politics. The allegation is that the money's being funneled in a way to politically benefit the Conservative Party. The claim has permission. There are grounds about Equality Act, lack of transparency. I think there may also be subsidy control, what we call state aid issues about all of this. So I think the Levelling Up agenda itself is likely to generate high court litigation beyond just this case in the next few years. And then finally, I just want to talk about some other trends, and really I'm focusing here on the Planning Act 2008. It's been quite a year for successful legal challenges to DCOs under the 2008 Act, with the first 4 successful challenges having taken place of grants of DCOs. There was in the past a successful challenge of a refusal of a DCO. 2 of them were consents to judgment, including Manston Airport, and 2 of them were claims that were taken to the High Court and were quashed, including, I think, most well-known Stonehenge, but obviously also the Norfolk Vanguard. I think this is a trend that's likely to continue. I did a similar talk to this back in 2008-9, where I predicted similar things. It's taken a bit of time for it to come to fruition. But for me, DCOs always looked like they were going to be vulnerable to this because they were the most complex projects, the most controversial projects, with time limits for their decision making and limited oral evidence to expose the issues. So I've always thought that that made them particularly vulnerable to successful challenge. It's taken a while for that to materialize, but I think that's going to be a future trend going forward. And then linked to that, we've seen a rise in the number of judicial review challenges to MPSs. So the adoption of MPSs, so obviously we had the Heathrow litigation, which was 6 judicial reviews of the AMPS. But also the other big trend that's coming is refusals to review national policy statements, or to refuse to suspend a national policy statement while it's being reviewed. And so this, we've already had the Vince judicial review in relation to the failure of the Secretary of State to review the energy MPSs. That settled when the review was announced. We've had threats of judicial review against the Secretary of State's decision in September not to review the airport's national policy statement, although those challenges don't seem to have materialized. And then just at the end of last week, you may have seen that it's been revealed there's another judicial review of the government's decision not to suspend the national networks MPS while it's being reviewed. That decision itself is being now challenged by judicial review. And the rise of these challenges to MPSs seems to me to be driven by cases like Thames Blue Economy and Scarisbrick, but also the Heathrow litigation, which show you that unless you challenge the MPS, it gives support and limits the number of arguments you can make to oppose development on DCO in such a way that you can't really allow the MPS to remain unchallenged. Now, this bit about review, I mean, review really is proving to be tricky under this Act. It was built into the Act in Section 6. But where a Secretary of State decides not to review, or decides to review but then not change, or to review and change, at each stage, Section 13 provides a right to challenge that by way of judicial review within 6 weeks. So it's a kind of built-in obstacle course of judicial reviews when the Secretary of State is asked to review. And you can see what's happened, in the airports litigation. The case fights all the way to the Supreme Court. The MPS is upheld. You've then got repeated requests to the Secretary of State to review the policy, which is only just adopted and which has been upheld, and people threatening to challenge that in various ways. And Section 6 is a bit of a weird provision. It sort of says when the Secretary of State is deciding whether to review, the Secretary of State must consider 3 things, although it's not exclusive. Those are, has there been a significant change? Was the change unanticipated at the time? And would it potentially have made the policy different? I think Section 6 is going to be a real issue because MPSs are supposed to be there to provide certainty for the 2008 system. if they are not just subject to challenge when they're adopted, but subject to constant attrition of people making requests for reviews, judicially reviewing the refusals to review, or the failure to actually change the policy, it's going to undermine the whole purpose of having MPSs. And the government relatively recently issued some guidance on how you should carry out reviews. I don't think, unfortunately, that's going to stem the tide. There is a kind of systemic problem with the way Section 6 and Section 13 are set up that naturally lend themselves to people using it as a tool and a weapon to stop major infrastructure projects. And I think that's going to continue. We've already seen the beginnings of it very clearly over the last year or so. So those are my thoughts on the future trends for judicial review. I'm now going to hand over to Georgina, who's going to be dealing with practice and procedure update.
Thank you, James. Hello, everyone. As James said, I will be delivering my talk about the practice and procedure updates for High Court judicial review planning challenges. Unlike James and Tim, who have focused on future changes and trends in this field, my talk will be more focused on recent updates in the rules and the case law for planning High Court challenges, to hopefully give an overview of the practice and procedure for such challenges as it stands now. As you can see from this first slide, I will be dealing with 7 subtopics: the new Part 54 practice directions, the issue of disclosure and duty of candor, new directions for oral permission hearings, Aarhus costs, some more general points on costs, the power to set aside a refusal for permission to appeal, and the issue of delay. So looking first at the new practice directions for Part 54. So before the 31st of May of this year, CPR Rule Part 54 practice directions were supplemented by 4 practice directions, A, C, D and E. However, from the 31st of May this year, amendments came into force to these practice directions, and they're now 4, as you can see on the slide: A, B, C and D, as well as some guidance on administrative court electronic bundling. The rules in relation to planning court claims, so the rules under practice direction 54D, have remained relatively unchanged. But the main changes, and which are significant across all judicial review, but including planning judicial reviews, are in relation to practice direction 54A. And it's interesting to note how these changes came about, or what prompted them. And it was mainly concerns expressed in a number of Court of Appeal cases, including perhaps most prominently Dolan, Secretary of State for Health and Social Care. And in this case, the court highlighted a number of important issues. They stressed the need for procedural rigour, the need to avoid excessive prolixity and complexity in what are supposed to be concise grounds for judicial review, and the need to avoid a rolling approach to judicial review. And by a rolling approach, the court was referring to a tendency for claimants to seek to challenge fresh decisions which have arisen after original challenge by way of amendment to an existing claim. And this is something the court said litigants should avoid. And for some context as well, in that case, the statement of facts and grounds ran to 87 pages long, and the supplementary grounds were another 13 pages. And the court commented that it was impossible to see how such statements can be regarded as complying with the requirement for documents to be as concise as reasonably possible. And those comments perhaps explain the changes to Practice Direction 54A, which now impose the following page limits in relation to High Court judicial reviews. So statements and facts and grounds must be limited to 40 pages, summary grounds 30 pages, detailed grounds 40 pages, skeletons 25 pages, and hearing bundles, if they're more than 400 pages, then they need to be split into a core bundle and a supplementary bundle. Now moving on to the issue of disclosure and duty of candor, and I'll deal with this in 3 separate stages: the pre-action, pre-permission and post-permission stages, because different rules apply at each of those stages of proceedings. So at the pre-action stage, this isn't actually dealt with by Practice Direction 54A. Instead, it's dealt with by the Judicial Review Pre-Action Protocol. And the most important or most relevant aspects are in paragraphs 13 and 23. And paragraph 13 tells us that requests for documents, so disclosure of documents, should be proportionate and limited to what is necessary for the claimant to understand why a decision has been taken. The defendant should comply with any request to meet these requirements unless there is good reason not to do so. And if the court considers that a public body should have provided relevant documents or information that it has failed to do so, it may impose cost sanctions. Further, in paragraph 23, the protocol requires the defendant to respond and enclose any relevant documentation, and if it fails to do so, explain why such documents have not been enclosed. And similarly, where documents can't be provided within the timescale required or requested, then reasons must be given for why this failure has occurred. At the pre-permission stage, this is dealt with in part by Practice Direction 54A. Paragraph 6.2 in particular deals with disclosure, and in short, it requires, it imposes an obligation to identify succinctly the relevant facts and provide a brief summary of the underlying reasoning, unless permission can be determined without that information. And with regards to the duty of candor, there's been quite a long-standing debate about whether this applies at the pre-permission stage. Interestingly, Practice Direction 54A, as amended, makes no mention to the duty of candor at this stage. And this is relatively significant because it contrasts with the post-permission stage. The post-permission stage is dealt with also by Practice Direction 54A in paragraphs 10.1 and 10.2. 10.2 is not a new provision, and it states that disclosure is not required unless the court orders otherwise. However, paragraph 10.1 is a new provision, and it's significant because it is the first time that there has been explicit reference to the duty of candor in the CPR rules on Practice Direction. It suggests, therefore, that the duty of candor obligation is most clearly engaged at the detailed grounds or evidence stage rather than earlier. And it's interesting that that duty is expressed as focusing on identifying relevant facts and underlying reasoning, rather than on any focus on the provision of documentation. Next, I'm just going to say something really briefly about new directions that have been issued in relation to oral permission hearings. These obviously apply across judicial review, but are also relevant for planning cases. And they do not form part of the practice direction. They are being rolled out. And these directions require that a hearing for a renewed application will be listed for only 30 minutes, which includes time for both submissions and judgment. The claimant must file an electronic permission hearing bundle within 14 days of the letter. If the claimant wishes to produce a skeleton, this must be filed 7 days before the hearing and be no more than 10 pages. The claimant must file an authorities bundle 7 days before the hearing. Failure to comply with these directions can result in the case being referred to a judge to consider whether it should be struck out or another order being made. And any application to vary these directions must be made on notice to any defendant and interested party. Moving on to the issue of costs, firstly dealing with Aarhus costs, and there have been two recent cases relevant to the rules applying to Aarhus costs. The first is Friends of the Earth and Secretary of State of Transport, which was a judgment handed down in January of this year. And this was a judgment on costs issues following the Heathrow Airport litigation. And in that case, the Court of Appeal had ordered the Secretary of State to pay the costs of Friends of the Earth, amounting to £70,000. This was £35,000 as per the cap for the divisional court hearing and £35,000 as per the cap in the Court of Appeal. This judgment considered the short but important point as to whether VAT was payable on top of that £70,000 sum. So in other words, the legal question was whether the cost cap specified in CPR Rule 45.43 was inclusive or exclusive of VAT. And the court held that the capped costs recoverable in an Aarhus Convention claim are absolute and unqualified figures, and therefore they fall to be treated as inclusive of VAT. So in other words, the Secretary of State did not need to pay more than the £70,000 they were ordered to pay in costs. And following that judgment, there was another case, CARA, the Croyd Area Residents Association case, where judgment was handed down in March 2021. And in that case, the original cost order had been made for the defendant and interested party to pay the claimant's costs, capped at £35,000 plus VAT. And essentially the interested party applied for that order to be varied to take account of the decision in Friends of the Earth, such that the cost liability was limited to only £35,000. And the court held that it was the fair course to vary the order to reflect their proper meaning of the CPR as was determined in the Friends of the Earth litigation. Now moving on to some more general points on costs. Firstly, dealing with multiple costs at permission stage of a judicial review. There's been a recent case, CPRE Kent, in which the Supreme Court considered a challenge to the position established in Mount Cook, which is that if permission is refused at a permission stage, multiple defending parties are prima facie entitled to seek costs of their acknowledgement of service and summary grounds from the claimant. And obviously this case applies across the spectrum of judicial review, but it's particularly relevant in planning cases where there is often a defendant and interested parties. And it was argued in CPRE that the current position with regards to multiple costs was inconsistent with the decision in Bolton, which was a planning case, which held that where there was multiple representation in a substantive planning judicial review, the losing party will not normally be required to pay more than one set of costs. And in their judgment, the Supreme Court noted three important points before coming to their decision. The first was that the inconsistency alleged with Bolton was rejected on the basis that Bolton could be distinguished. Bolton concerned the awards of costs at a substantive hearing, whereas Mount Cook costs apply at the permission stage. And furthermore, the decision of Bolton predated the introduction of the CPR rules, which introduced the acknowledgement of service procedure. Secondly, they noticed that despite the fact that there had been calls for the Civil Procedure Rules Committee to address applications for cost at the permission stage, no amendments of this kind have been made. And also that in planning cases, costs are generally capped in any event by the Aarhus Convention. And as a result of after noting those points, the Supreme Court went on to ultimately hold that when permission to seek review is refused, the claimant may be liable to more than one defendant or interested party to pay the cost of preparing their acknowledgement of service and their summary grounds. It's not necessary for the additional defendant or interested party to show exceptional or special circumstances in order in principle to recover those costs. However, to be recoverable, those costs must be reasonable and proportionate. So, for example, if there is an obvious lead defendant and the court was not assisted by the acknowledgement of service or summary grounds of an additional defendant or interested party, then the costs of that additional defendant or interested party may not be considered to be proportionate and so may be recoverable. However, that is an assessment that would take place on a case-by-case basis and wouldn't be necessarily susceptible to more general rules. Also on the issue of costs is the determination of cost issues in relation to the principle in Gourlay, and this principle was reiterated and applied in the CPRE judgment. And the principle is that the Court of Appeal has responsibility for monitoring and the developing practice in relation to costs orders, and that the Supreme Court will generally be slow to interfere in such matters absent an error of law of general public importance. Specifically in CPRE, the Supreme Court noted that it was wrong to treat the Court of Appeal's rulings on principles of practice as binding legal precedents from which it could not depart. Nonetheless, it was appropriate for the Court of Appeal to review a decision laying down a principle of practice where there is sufficient reason to do so, such when there has been a material change in circumstance or where a previous case has been decided per incuriam. Now moving on to the power to set aside a refusal for permission to appeal. And this is a power under CPR Rule 52.30. Understanding this procedural rule and its scope is particularly crucial in the context of planning, given it's very important for clients to have certainty of when a challenge to a planning permission is final. In some ways, the fact that this regime exists in and of itself undermines that certainty. However, when you look at the wording of CPR Rule 52.30, it can be seen that a very high test must be met in order for it to apply. So as we can see, the Court of Appeal or High Court will not reopen a final determination on any appeal unless it is necessary to do so in order to avoid real injustice. The circumstances are exceptional and therefore make it appropriate to open the appeal, and there is no alternative effective remedy. And indeed, the difficulty in meeting this test was recently reiterated in the case of Wingfield and Canterbury County Council. The exceptionality of circumstances where CPR Rule 52.30 will apply was evident from the opening paragraphs of that judgment, which state, the question raised by these renewed applications, put at its simplest, is this: when must an unsuccessful litigant accept no for an answer? And the Court of Appeal went on to hold that unmeritorious applications under 52.30 undermine the principle of finality in legal proceedings. It also said that they impose unnecessary burden on the court's resources, impede access to justice for litigants, and are damaging to the rule of law. So the lesson learned from that judgment is that CPR Rule 52.30 should be used very sparingly. However, that's not to say that it can't be used effectively. And there has been a recent case, Mariana and BHP Group PLC, which is not a planning case or a judicial review case, but it has wider significance because it demonstrates CPR Rule 52.30 being successfully relied upon. These proceedings arose out of the collapse of the Fundão Dam in southeastern Brazil, and the claim was brought to determine the liability of those who owned the dam. The High Court originally struck out the claim as an abusive process. Permission was then sought to appeal the strikeout, which was refused on the papers. And relying on CPR Rule 52.30, the claimants then appealed against that refusal of permission to appeal the strikeout. And the court held that the stringent test imposed by CPR Rule 52.30 was satisfied on the facts of that case, because in refusing permission, the judge had failed to address the essential point that went to the heart of the claimant's challenge. That failure critically undermined the integrity of the process for determining permission to appeal. And if the judge had grappled with the essential point that there was a powerful probability that the outcome would have been different and he would have granted permission to appeal. However, it's important to note that the judgment did indicate that this was a most unusual case and the claim was of exceptional importance. And therefore the conclusion on CPR Rule 52.30 is that it can be relied upon successfully, but the circumstances will need to be exceptional in order for it to satisfy the test. Finally, moving on to delay, there have been two recent planning cases relevant to the issue of delay. The first is Croyd Area Residents Association, which I referred to earlier. This was a High Court judicial review of a grant of planning permission dating back to 2014. And the facts of this case are quite striking. The purpose of the 2014 permission had been to extend the operating hours of a holiday park. However, the permission referred to a red line map, which mistakenly covered an area much wider than intended and included land which was not only not owned by the applicant, but was also in an area of outstanding natural beauty. For 4 years, the legal effect of the mistaken planning permission was not noticed. However, in January 2018, the interested party applied successfully for a certificate of lawfulness to use the wider area to station caravans on, relying for the first time on the unintended aspect of the 2014 permission. A group of local residents were upset by the introduction of these new caravans brought a judicial review, but challenging the underlying 2014 permission. And it was crucial for this case that it was not disputed by any parties that the 2014 permission had been granted in error of law, but what the court had to consider was whether A, the judicial review was statute barred by section 284 of the Town and Country Planning Act 1990, and B, if it was not, whether there was good reason to grant an extension of time to allow the judicial review to be brought. The court held that the claim was not statute barred, and it went on to exercise its discretion to grant an extension of time. This is quite stark, given that the judicial review was issued more than 6 years late at this point, that subsequent to the granting of the planning permission, a lawful development certificate had been obtained based on it, and that lawful development certificate had not been challenged in the 6 weeks allowed under the Planning Acts. In coming to its decision, the court did highlight that this was an entirely unusual, unique, and very fact-specific case. But there were two overriding factors which, in the court's opinion, supported its judgment for extending time. The first of these was that significant harm would flow from upholding the permission, given it would allow for development in an area of outstanding natural beauty which had never been lawfully permitted. And the second was that if permission was granted, and it was in relation to a planning permission that had been granted in complete error, then it would undermine the credibility of the planning system. It's interesting to note as well that this case was granted permission to appeal to the Court of Appeal, but it has no longer been pursued. And finally, another case on delay, Flyden Coast Farm. In this case, the Supreme Court considered time limits that apply to judicial review challenges in relation to neighbourhood plans under Section 61N of the Town and Country Planning Act. And the making of neighbourhood development orders or plans is a 7-step process, with Section 61M making separate statutory provision about public law challenges in relation to steps 5, 6 and 7 of that process. And in reality, the provisions are quite similar. The challenge must be brought by way of judicial review within 6 weeks of the step in question being completed. And the court in that case was required to consider the scenario where a challenge is brought to the making of a development neighbourhood order or plan, which is based upon a challenge to an earlier step in the process, which is said to invalidate the plan of it in and of itself. And the court held essentially that such a challenge was not allowed, that a party cannot wait to challenge for errors in stage 5 or 6 of the process until the end of stage 7. In other words, a challenge to performance of step 5 of the process must be brought within 6 weeks of completion of steps 5, and not within 6 weeks of the making of the plan itself. So that's the end of my talk. I hope that has been helpful. Thank you for listening. And I will now pass over to David Elvin QC, who will be presenting a Habitats Case Law Review of the Year.
Thank you, Georgie. I'm going to be talking about 2 areas which dictate potential future developments, and like James and Tim, I'm actually going to focus on some aspects of the new Environment Act which will dictate what is going to happen in the coming years. There are amendment powers for the habitats regs, as well as other powers which will interfere with the way in which habitats and species are protected as they currently are under the regs. And then I'm going to look at a few critical cases, the most important of which is the Wyatt case, which deals with nutrient neutrality and appropriate assessment, which has a major impact on new development, particularly housing, but not restricted to housing. In addition to that, there are a number of wildlife licensing cases which always appear to generate objection and challenge. Dealing very briefly with the Environment Act, there are new provisions, sections 112 and 113, which allow amendments to the regs. Why specific powers are needed to amend regs, I'm not entirely sure, but there it is. It's part of an overall attempt by government, I think, to appear to be preserving biodiversity and improving it, given our exit from the EU. One major provision which was added in the House of Lords and which didn't survive parliamentary ping pong was what was clause 115, which would have introduced a principle of non-regression, which would have been a mandatory duty on the Secretary of State not to reduce the protections below those currently available, which had been in the earlier versions of the Brexit agreement, but which didn't make it into the final version. They were in the first version of the Northern Ireland Protocol. So there are provisions to amend the general duties and Part 6. As I say, the reasons appear questionable. 112 allows amendments to general duties, in particular the general requirements under Regulation 9, and you'll see that they're fairly wide powers, but they are in relation to purposes which relate to biodiversity and improvement in the natural environment. There are some interesting provisions in that the Secretary of State is required to make those amendments for specific purposes. And there are 2 duties which are rather weaker than the clause 115 non-regression duty. There's a have regard to duty to promote conservation and biodiversity, which of course is only as effective as the Secretary of State actually having regard. And then the power to make regulations, the Secretary of State has to be satisfied that it doesn't reduce the level of environmental protection. What the difference is between that and the clause 115 absolute duty appears to give the Secretary of State some wiggle room, but he must lay a report explaining why he is satisfied before Parliament, and to publish a public statement to that effect and carry out such consultations as he considers appropriate. Again, this all gives much more discretion to the Secretary of State rather than the absolute duty which the House of Lords had preferred. Section 113 is the general duty to secure compliance with the directives under Reg 9, and allows amendments to allow a movement away from the European model from the directives, and to set out the purposes which must be considered when functions are to be discharged. Again, one rather suggests, although there's a lot of noise, as there has been throughout in the policy papers, as to world-beating standards and meeting binding international obligations, one does remain slightly concerned as to the need to carry out the changes, because inevitably it seems directed to giving greater discretion and removing some of the protections. And you'll see again similar powers and similar restrictions in section 113 have regard to satisfied they don't reduce the level of environmental protection. The other interesting feature is that it's said to create greater certainty in the habitats regulation. See the September 2021 policy paper. And you'll see the explanatory notes, or at least the version we have at the moment, which was for the House of Lords amendments, to make the processes clearer and more legally certain. I'm not entirely sure what is legally uncertain about Part 6. It's been thoroughly litigated. Lord Carnwath's judgment, of course, in the Champion case being a landmark in national authority, but applying well-established authorities such as Sweetman and indeed the Wadensee case some years ago. Although issues have been generated about the application of those principles, the principles themselves are very clear. One of the cases I'm going to touch on neutrality is an application of those principles. So again, one is left slightly with the suspicion that the purpose of all these provisions may be to make the provisions more flexible, that is to say, less certain, and also less protective of biodiversity, and contrast the habitats review in 2012, which focused on streamlining the procedures, but did actually give a view which is contrary to that set out in the explanatory notes and the current policy paper. I'm just going to touch very briefly. There are a series of strategies which are introduced by the Act. There are species conservation strategies and protected site strategies, sections 109 and 110, which give Natural England powers to carry out the drafting of strategies for specific areas or parts of areas within England, and to introduce measures for conservation and enhancement of habitats and for species. And they're both in very similar format. And interestingly, whilst they are to be subject to Secretary of State guidance, if issued, there is a duty on local authorities, planning authorities specifically, to cooperate with Natural England in the preparation and implementation of these strategies. It's the same under both section 109 and 110. And the impact, therefore, on the power of local planning authorities in terms of plan making appears to be potentially quite wide, because if they must cooperate in the implementation of these strategies, then it appears to be the case that that will reduce the extent to which they have a wider discretion under plan making, where, of course, they can take the view of Natural England and consult on conservation and biodiversity issues. But there only one matters to be weighed in the balance and subject to plan examination. But here there's a mandatory duty to cooperate, and query whether that cooperation extends to a state after the implementation of the, after the publication of the strategies, because implementation may well, it seems to me, cover the impact on local plan preparation. As I say, you'll see a similar position with regard to protected site strategies. So important issues for the future to see what happens with these strategies and what the Secretary of State's guidance is. There's another third set of strategies called local nature recovery strategies, section 104 to 108, which I haven't focused on because they touch on habitats protection rather less than the two sets of strategies I've just looked at. And they're also within the direct control of the Secretary of State rather than Natural England, but they also have similar potential. So turning from the future in terms of impact on habitats, amendment to the regs and other provisions which may impact on them, I turn to the most important case in terms of habitats this year, which is the Wyatt case, which deals with the growing concerns over nutrient neutrality. This is an issue which arises from the discharge of wastewater and other effluents into waters which are either protected themselves or which discharge into protected sites, SPAs and SACs. The Wyatt case concerned the Solent, which had a number of protected sites and 12 planning authorities. Natural England issued the guidance for the Solent and has, because of the importance and the difficulties, has been through 5 editions by 2020. There have been similar issues arising in other areas. And an example of this is in Kent, the Stodmarsh area has been subject to similar advice, and it's a common issue now. The terms of the Natural England approach came under scrutiny in the Wyatt case. There were a pair of cases which went before Mr. Justice Jay in the summer. The second case, the Say Warsash one, raised the same points but was determined in the Wyatt case. Warsash went down because of the breach of the rules of fairness, but not related to the habitats issues. Now, the advice that issued for the Solent explains the nature of the problem. And the problem is the impact of the nutrients and the relationship between the discharge of effluents into protected waters or waters into protected areas and impact on habitats is not clear, which of course raises immediate problems with the precautionary principle and meeting the objectives of appropriate assessment of not having an adverse effect on integrity, a matter which has, as you will be aware, to be demonstrated to a high level of scientific certainty and on the basis of best evidence. And so the approach that Natural England has devised, given those issues, particularly with eutrophication in protected areas, is to devise a methodology which seeks to achieve neutrality. So at the very least, it can be said there is not an adverse effect on integrity because the discharge is nutrient neutral. This is just as by way of illustration, this is the plan for the Solent area, and you can see the considerable area over which the catchments which discharge into the Solent extends, and this affects principally 12 planning authorities, so of quite considerable importance, particularly given the pressure on new housing development, which is one of the key problems. You'll see that a methodology is set out by Natural England, which I'm not going to go into, it makes it clear, though, that the local authority itself is to apply a precautionary approach and that the data will need to be updated and revised on a regular basis. You'll see at 4.6 in the guidance, nitrogen budget is calculated. I haven't gone into the details, as I've said, but there are significant details in the guidance as to how to deal with this. It builds in a budget and a buffer and is very precautionary. The issue which proved to be of particular issue, the issue which proved to be of particular concern in this case was one element in particular of the methodology, even applying a precautionary approach, which was the point that I've highlighted in 418 here, which was the average occupancy rates applied to the housing. This was a development for 4 and 5 bedroom houses, but the assumed occupancy rate was an ONS national figure derived of 2.4 per dwelling. And that was under challenge as being not sufficiently precautionary because it's 2.4, whereas it was said that the best figure for 4 to 5 bedroom houses was 3, not 2.4. And it was said, therefore, that the planning authority who had applied the guidance acted irrationally. Natural England said, well, it's based on the best evidence, but pointed out that there were significant other precautionary elements in the calculation, not least because, although there was not a direct proportional relationship, the amount of wastewater discharged by 4 and 5 bedroom houses was significantly less than that discharged by 1 and 2 bedroom houses. So they said there was a sufficient precautionary element built into the buffer. There were other precautionary aspects as well, but that was the main one. Mr. Justice Jay, who took a fairly rigorous quasi-scientific approach to the case, applied the approach he'd set out in Wealden a couple of years ago and drew a careful distinction between the duty on the local authority and the high hurdle to be overcome in habitats cases with the approach of the court to considering. And you'll see that at 29 and 30. The standard tests are reiterated. There's nothing new in those matters. Appropriate assessment, best scientific knowledge, determined as at the date of the decision. High standard of investigation, Waddenzee, Dutch nitrogen and the like, of course, applied by Lord Carnwath in Champion. He rejected contentions on the part of the claimant that Dutch nitrogen had created a new approach. He analyzes that and says, no, it's simply applying the same approach as established in the previous cases and indeed summarized in Champion. And he therefore went on to consider further principles, the fact that the competent authority should give condign weight, i.e. appropriate weight, to Natural England's advice, and applying Morge, if the authority is minded to deviate from the advice, it must give cogent reasons. However, if the advice was flawed, then of course that might be a basis for challenge, applying Wealden. Whilst it was clear that Mr. Justice Jay had significant concerns about the application of the national average, the 2.4 per dwelling, and said that the advice should be revisited and more focus placed on bespoke information for the particular development. As I say, best evidence in this case would have been 3 per dwelling rather than 2.4. But given the other ample precautionary assumptions built into the calculation, he didn't find that the grant of planning permission had been unlawful, and in general, other than the reference to the national average occupancy rate, he found the advice from Natural England to be, quote, impeccable. The other decisions I want to cover are just licensing decisions. RSPB in Natural England, that was the hen harrier scientific trial to try and deal with the persecution and population size of hen harriers, which of course predate on grouse chicks. The challenge was had been rejected by Mrs. Justice Lang at first instance. The argument was run that alternatives ought to have been considered, bearing in mind conservation objectives. The Court of Appeal, agreeing with Mrs. Justice Lang, held, since it was an application under 16(1)(a) of the Wildlife and Countryside Act, which was for scientific purposes, i.e. to look at assisting the populations of hen harriers, you had to apply the purpose for which the application was made, not some other purpose, i.e. 16(1)(a), not 16(1)(c). I should add that I missed it off. There was another licensing case also in the last year, Wild Justice and Natural Resources Wales, 2021 Environment Law Reports 24. That was a general license granted for Wales for the control, taking and killing of certain species of birds for the protection of crops, preventing serious damage to crops, and for public health purposes. We're talking about feral pigeons. The general licenses were granted in respect of feral pigeons, carrion crows, magpies, and the like. And the issue was whether the conditions were sufficient, held they were, and whether reasonable alternatives had been considered, given that these are general licenses and give a general power to kill and take, providing very strict conditions are observed. Then the judge held, it was His Honour Judge Jarman QC sitting as a deputy admin court judge, then the usual discretion to weigh the evidence applies to the decision maker, and sufficient consideration had been given and it was not irrational. The Langton case was the further stage in badger culling. Government study, next steps for the strategy of achieving bovine tuberculosis-free status. It was held that because biodiversity had been considered at the earlier stage in the process, Section 40, which is the biodiversity duty, which will be beefed up by the new duty introduced by the Environment Act, a public authority, when exercising its functions, must, so far as consistent with the functions, have regard to the duty to give effect to biodiversity. That was not engaged because it had already been considered and didn't have to be considered in the context of that specific policy paper. So for the future, I can see nutrient neutrality being a continuing issue, particularly since, as indicated in that case, Natural England proposed to roll out national proposals. Licensing continues to be a target for objections. I should point out that the Wyatt case on nutrient neutrality is currently before the Court of Appeal. Although judgment was given on the 28th of May, we're still awaiting a decision on permission from the Court of Appeal. I checked the case tracker this morning and it was only referred to a Court of Appeal judge on the 12th of this month. So it's been sitting in the court offices for about 6 months, but is now before a Lord or Lady Justice for consideration of permission. But watch this space. Thank you very much.
Hello. Well, thank you everyone for those very interesting and detailed presentations. We were hoping to have time for some questions. It's actually already almost 12:30 anyway, and so I'm afraid we're not going to be able to deal with very much. There have not been very many questions, quite specific, but I think the first question from Sonia Sharp was, what was the main reason why the OEP was created? It's going back to Tim Buley's talk. I think Tim Buley sort of explained that this is, to a considerable extent, an attempt to fill the gap left by the European Commission's oversight role. But I'd like to sort of turn it slightly to ask, well, given the decision to have an OEP, what was the point of creating this rather elaborate specialized environmental review procedure? Why not link it to, why not leave it to JR? And I was listening to James Maurici, there was a related point. He was saying of the complications that have been introduced by having a specialized procedure under the Planning Act for challenging things, which creates all sorts of problems. And it's rather curious that in the government's recent review of judicial review, it didn't actually look at why one has these specialized procedures. But coming back to you, Tim, I mean, what do you think there's any purpose in having this very specialized and rather fussy procedure for environmental review?
Yeah. Well, it's a really good question. I'm quite dubious about it, and I haven't said, but I was involved in giving evidence on the bill at various points to the Environmental Audit Committee, but I also worked with some parliamentarians over the summer who were looking at amendments to the bill. And I think where we got to was that actually it would be much better in many ways to leave it to judicial review. I touched very briefly on, for example, some of the problems that the OEP faces, because at the end of this investigation process, you then get into environmental review, which, as you say, is very fussy. And one of the curiosities is that it doesn't actually leave the OEP with any mechanism for enforcing its recommendations. It can't bring a judicial review because its bespoke power probably won't cover it. And it's got this rather curious ability. And I think it would have been much better to leave it to just to give the OEP a wider judicial review power let it have its investigations by all means and leave it at that. It's going to throw up lots of interesting work for people like me, I suppose, in working out what the limits of it are, but it doesn't make much sense. And, you know, much the same can be said about some of these other statutory procedures.
Right. Well, thank you. I thought that seemed to be with the just to what you were saying. I mean, James, are you there?
Yeah.
You could perhaps come in on this. I see there's a question from an anonymous attendee. Does the Paris Agreement and concomitant climate change commitments arguably constitute a change under Section 6B of the Planning Act, such as to trigger obligatory review? And that, in a way, sort of pointing out a point that you were making about the sort of having, again, this rather fussy procedure under the Planning Act, where almost anything can trigger a review and create great uncertainty.
Yeah.
About that?
Well, I mean, I think, you know, if you look at some of the recent things that have happened, so the Vince challenge to the energy MPSs and also the requests for review of the airport's MPS, they were predicated on changes to the climate change international context, so Paris, but also, you know, I suppose going beyond that. So, I mean, in theory, they could be the kind of thing that triggered Section 6. The thing is, they have to also be not just significant changes, but not anticipated and likely to change the policy. So in Vince, we know the government ultimately decided to review the energy MPSs. They were very old. They didn't reflect where we were on climate change conventions, you know, 10 years on. So they made a decision to review. On the airport's MPS, I think the position's different because, you know, Paris was contemplated, it was known about. And the AMPS has a built-in mechanism, which is that when you apply for the DCO, that's judged against whatever the climate change commitments are that have been incorporated at that point. So I think, you know, and obviously the government rejected review of the AMPS. I don't know whether it's partly on that reason. So, I mean, I think these changes could be significant changes, but whether they meet the other criteria is possibly open to question. And it does just depend on the circumstances. You know, I think on the airport's MPS, it's quite clear it probably isn't good enough to trigger Section 6 in my view. But on some of those older MPSs like energy, there's also the challenge to the national networks one, then potentially, yes, it could be.
Yes, I mean, I don't know whether either David or Georgina want to come in. Do you want to add anything on there? No. I think, you know, I was just really wondering whether the government's going to find itself needing a review, not a judicial review as such, but actually of these sort of different procedures that they've put in place, which actually may be causing more problems than they're worth. But I mean, that's coming from someone who's out of the battle now.
Robert, one of my concerns with the Environment Act is the multiplicity of new strategies and procedures that are being brought in, which are going to so overcomplicate local plans, habitats. I mean, I just touched on the top of the problem, because there are conservation strategies and all sorts of other things, conservation covenants. The whole thing is going to potentially become very messy.
Yeah. Well, I think that's probably a subject for another webinar. We've got a rather specific question about VAT costs, which were agreed as part of a consent to a judgment on a JR where the order was only made this month. I think that's a sort of response to Georgina's point that VAT under Aarhus, VAT is treated as inclusive. But I suspect that's a rather specific question, which rather depends on the terms of the particular agreement. So, but by all means, seek advice from one of our speakers on that. Finally, there's an anonymous question. With the OEP, how popular does the panel think it will be with the public LPA's Act? Although the OEP doesn't have a time limit for making a JR, third parties do. They are likely to be reluctant to wait for the OEP to decide whether or not to initiate JR. And so, well, I think that's rather goes back to my question really, which is, what's the point of this elaborate new procedure? And actually, people like Client Earth and so on are likely to get on and do their own JRs. I don't know what you think about that, Tim.
Yeah, I agree. I mean, the difficulty which the third party, so popularity with the public, I think, is a question for politicians rather than people like me. But for environmental campaigners and the like, what you would have to do, you make your complaint to the OEP, you have to be successful before the OEP, but then the OEP can't give you a remedy, it can only make recommendations for the future. And then you're reliant on the OEP to decide to bring this further process. And I think that's not going to be attractive to people like clientele and the like. I think, as Lord Carnwath says, they're going to bring their own cases if they're going to do it at all. So I think there are real limitations with it, but we shall see.
Right. Well, I think at that point, we'll have to bring this proceedings to a close. And a final thank you to all our speakers for the work they put in. And thank you very much, all of you who've been listening. And by all means, let us know if there are comments you have about the way this procedure was presented. I think this is the last one, isn't it, of these three, but it's something that Landmark has done each year. And hopefully we'll get back to being able to do it in person. I'd love that. Anyway, for the moment, goodbye and thank you for your attention.